48 hours. That's all the time Stephen Miller was given before everything changed. No long delays. No endless negotiations. No escape hatch buried in legal paperwork. Just a federal judge, a direct order, and a countdown already ticking in real time. Inside a silent Washington courtroom, Judge Tanya Chutkan looked at months of resistance, months of stalling, months of carefully calculated delay tactics, and decided she'd had enough. What she issued next sent shockwaves straight through political circles, legal circles, and everyone watching this battle from the sidelines. Because this wasn't just another procedural ruling. This felt personal, precise, surgical. And the most dangerous part? It wasn't about what the public already knows. It was about what might still be hidden. Stephen Miller built his entire reputation on confrontation. Aggressive policy fights. Explosive television appearances. Immigration crackdowns that made him one of the most polarizing political operatives in modern America. Conflict became his brand. Pressure became his oxygen. But this time, the pressure isn't coming from cable news hosts or political opponents. It's coming from a federal judge with the authority to force compliance. And Judge Chutkan has a history that matters here. She doesn't bluff. Inside legal circles, she's known for something politicians hate most: deadlines that actually mean something. When she issues an order, she expects movement. When she sees delay tactics, she tightens the timeline. And that's exactly what happened here. The ruling landed with almost no room to maneuver. 48 hours to turn over documents Miller's team allegedly fought to keep hidden for months. Emails. Internal memos. Communications tied to key policy decisions during one of the most controversial periods in recent political history. Documents that could reveal not just what decisions were made, but how they were made behind closed doors. And that's where the tension started building fast. Because this deadline didn't come out of nowhere. According to the court, there had already been months of incomplete cooperation. Delayed responses. Legal objections stacked on top of legal objections. Executive privilege. Attorney-client privilege. Deliberative process privilege. The standard legal shield used when political figures want to keep sensitive communications buried. But then something shifted. Quietly. Judge Chutkan reviewed the claims, and apparently wasn't convinced. Her order made one thing painfully clear: she believes these protections either don't apply, or are being stretched beyond recognition to keep critical evidence hidden. And then came the part that changed the entire mood in Washington. The timeline. 48 hours isn't random. It's strategic. Long enough that Miller can't claim impossibility. Short enough that he can't build another wall of procedural delays around the documents. In other words, the judge removed the exits before announcing the fire. And that's when legal analysts started paying very close attention. Because once a federal judge corners a political operative with this kind of precision, the next moves become incredibly dangerous. Every response carries consequences. Miller now has 3 choices. Full compliance. Partial compliance with objections. Or outright resistance. Each option creates a completely different political explosion. Comply fully, and critics will say accountability finally caught up. Resist, and the court could move toward contempt sanctions, escalating fines, or even harsher penalties tied to ongoing proceedings. But here's what no one expected. Judge Chutkan anticipated almost every loophole in advance. The order reportedly includes detailed instructions about redactions. Miller's team can't just black out half the pages and claim victory. Any withheld material must be justified line by line, document by document. That level of specificity tells you something important. The judge expects resistance. She prepared for it before the clock even started ticking. And then, silence. The kind of silence that spreads through legal teams when everyone realizes the usual playbook may not work anymore. Emergency appeals? Difficult under this timeline. Delay motions? Hard to justify after repeated court warnings. Procedural maneuvers? Running out of runway fast. Suddenly, a man known for aggressive confrontation is staring at a shrinking list of options. And the documents themselves may be the real story here. Not because of what they definitively prove. Nobody outside the legal teams fully knows that yet, but because of what they could reveal about internal government decision-making during critical moments behind closed doors. Email chains. Draft policy language. Meeting notes. Conversations between officials during some of the most controversial policy battles in recent memory. These are the records that show process. The arguments people made privately. The warnings they received. The information they ignored. Public statements are polished. Internal communications are not. That's why these documents matter so much. They can transform a political narrative overnight. And Judge Chutkan knows it. Which is why the pressure feels so intense right now. This isn't just about Stephen Miller anymore. This is about whether courts can force transparency from powerful political figures who spent years operating behind layers of privilege and institutional protection. It's judicial authority colliding head-on with political resistance. And neither side appears willing to blink first. Meanwhile, inside conservative political circles, the calculations are already beginning. Supporters may frame this as persecution. Critics may frame it as overdue accountability. But underneath the political theater sits a far more dangerous question. What happens if Miller refuses? Because federal courts don't issue orders like this casually. And they don't set aggressive deadlines unless they're prepared to enforce them. Contempt sanctions. Daily financial penalties. Adverse inferences that could damage future legal defenses. All of those possibilities are suddenly on the table. The courtroom battle is rapidly becoming a test of institutional power itself. Can a federal judge compel compliance from someone who built a career resisting institutional pressure? Or does political influence still create a shield strong enough to outlast the courts? That's the real fight happening underneath the headlines. And every hour that passes makes the confrontation more intense. Somewhere right now, attorneys are reviewing emails, weighing risks, debating strategy. Somewhere, political operatives are calculating public fallout. Somewhere, people are asking the same question quietly behind closed doors. What's actually inside those documents? Because if the material turns out to be explosive, this 48-hour deadline may become remembered as the moment everything shifted. Not when the final ruling came down. Not when the investigations started. But when a federal judge decided the delays were over. Watch what happens next carefully. Watch whether Miller's team complies immediately or starts pushing back publicly. Watch whether emergency motions suddenly appear overnight. Watch the language from political allies. Sometimes the loudest signal comes from silence. Because if key figures stay unusually quiet while the clock runs down, that tells you they understand how serious this really is. And make no mistake, the clock is running now. 48 hours. A federal order. A judge who refuses to back down. And documents powerful enough that both sides are fighting desperately over who gets to see them first. Whatever happens when that deadline expires, it won't stay inside the courtroom for long.